Hello, I'm Sarah Thompson Copsey and welcome to today's webinar for Legal Futures, Changing Renewal Lease Terms under the 1954 Act. The Landlord and Tenant Act 1954 gives tenants security of tenure, and we all know that that means that at the end of their lease, the tenants are entitled to a new lease unless the landlord opposes that entitlement, and in order successfully to oppose that entitlement, the landlord needs to show at least one of the 7 statutory grounds of opposition. If the landlord is not opposing the tenant's desire to renew its lease, or if the landlord fails in its opposition, then the tenant is entitled to a new lease. And when we think about the 54 Act and the terms of that renewal lease, we think about the lease being on the same terms and conditions as the old expired lease, subject of course to an open market rent. But in fact, it's a little bit more than just that. So we're going to look today at what it is that the court can award in terms or order in terms of the terms of the clauses of the new lease in connection with both the property. So what is actually the demise under the lease, the length of the lease, how long will it actually be, the term of the lease, the rent under the lease, which is where most of the disputes arise, and then the court's overarching power under Section 35 of the Act to deal with the other terms of the lease. It's not obligatory to take a new lease, and the tenant does have a choice at the end of the day. It can withdraw its claim for a new lease, or it can simply bypass the court and agree with the landlord the terms of the new lease.